Hello, good evening. Welcome to everyone in the room and everyone who's joining us online this evening's session. Property law nuts and bolts. We're at part 5, apparently, forfeiture where to begin. Where indeed, if you talk to lay people about the law of landlord and tenant, one of the few words or buzzwords they might have heard about in association with that topic is forfeiture. It certainly brings mixed feelings to the mind. Some lawyers, me certainly, spent a long time when I was a bit younger litigating about forfeiture, mainly in the Willesden County Court, where we used to turn up £60 a pop to have a go at the tenants who wouldn't pay their rent and creating noise. Television's too loud and so on, and their leases had been forfeited or made the subject of service of some statutory form of notice or another. But at the root of all of that was the law of forfeiture, the doctrine of election, to which that gives effect. And it is a seminal part of the law of landlord and tenant. So we're fortunate to be hearing some of the elements of that this evening. There are a couple of housekeeping matters to get out of the way, mainly for people who are listening or watching online. The first is that your microphones are muted automatically, apparently, so you don't have to worry about that. Questions are welcome. I think the thing we'll do is take them at the end. But if you're watching, listening online, then I think you can type them in to a text box. And if you don't want your name to be associated with your question, then tick. Apparently there's a box saying send anonymously, and that way your credentials will be entirely ring-fenced. We will then look at least some of the questions at the end of the presentations. And so if you lose a connection at any point during the webinar, just rejoin in the time-honoured fashion. The first of our speakers this evening is Sophie Gibson, who joined us relatively recently. She's the most junior property barrister in these chambers. She specialises in all aspects of the law of landlord and tenant, commercial as well as traditional chancery matters and residential matters as well. She also practices in planning, which is one of the characteristics of these chambers, that we have these sort of useful crossover areas. And last month, I see from the notes, she won her first planning inquiry, so well done. And Sophie has a busy court practice with papers as well. And she has 2 possession hearings this week, trial, which she says is starting tomorrow. So I wonder what she's doing here.
You and I both.
And also, I think later this week, is it your first appeal as sole counsel?
Yes.
Yes. Okay. Right, we better get on with it then. And as well as that, she's led quite often at the moment, including by Justin Bates, who's got a case coming into the Court of Appeal about the right to manage. So over to you, Sophie. Introduction.
So I'm talking about the introduction to forfeiture. Essentially, what is it? When can you have it? How do you do it? When can't you do it? And if you can, should you? And the relevance of that picture of I'm going to get a child doing some gardening will hopefully become clear as we go on in this talk. So what is forfeiture? Now, this definition on the screen was labelled a good working definition by the Supreme Court. So I'm going to take it, it's quite good if it's been endorsed by the highest court in the land. That is a right to determine a lease by a landlord if A, when exercised, it operates to bring the lease to an end earlier than it would naturally terminate, so in a fixed term at the end of that fixed term, or if it's periodic, the date when it could terminate by notice to quit. And second, it's exercisable in the event of some default by the tenant. And it's a unilateral right of the landlord, and hence it has been labelled the ultimate affirmation of the landlord's proprietary power. But before we go any further, bear in mind, if any of you work with properties in Wales and any residential premises, this right has been excluded following the 2016 reforms in relation to occupation contracts, which, if you go into the actual see in more detail, but essentially an occupation contract is a contract between a landlord and an individual giving a right to occupy, essentially being any tenancy or a license regarding homes. So if you intend to try and forfeit a residential premises in Wales, stop. So the basics about forfeiture. As I've already outlined, it is the landlord's contractual right to terminate if certain events happen. And it's also known as the right of re-entry, because one way of, for instance, exercising this right is to re-enter the property, and more broadly speaking, it is a way of reclaiming back property as part of, the landlord's ownership. And generally speaking, forfeiture takes place before the end of a term and upon tenant default, and I'll discuss later on which instances of default are applicable. Generally as well, if there's no re-entry provision or forfeiture clause in the lease, you can't forfeit, but there are some exceptions to that I'll briefly address. And I think later on in the waiver and the relief perhaps discussions will be addressed in more detail that forfeiture is not compulsory. You can choose to forfeit or treat the lease as continuing. And that comes into the point if you can forfeit, should you? And then in the relief section, there'll be addressed in more detail the people who can apply for relief and what relief means. But overall, if the lease is forfeited, then it will be terminated, and so will any derivative interest deriving under that lease. Now, here is an example of a forfeiture clause. It's not mine. I don't proclaim that it's mine. I've taken it off practical law. So here's I presume, pretty solid. It's on there. And you can read it yourselves. I assume most of you have seen one before, or at least got a subscription to PLC to go and access it yourself, and any drafting notes there too. But overall, it provides the landlord's right to re-enter upon certain instances. Generally, they're split into what happens if the rent's unpaid, or if there's any other breach of condition or covenant in the lease. And that covenant condition rent distinction is important, and that'll be addressed later on. Particularly important in the relief context and how you activate the right to forfeit. And then 44.2 just clarifies what happens if property is re-entered. Now, the question of can the landlord forfeit? Generally, there's two main types of breach here that we're concerned about: covenant or condition. And as I've addressed before, the right to forfeit bites upon there being some breach. And I assume you've all seen covenants before, generally positive or negative, a promise to do positive or not to do negative something. For instance, a classic one is a promise or a covenant not to use, assign or sublet without prior consent. It is possible to forfeit for a breach of a repair covenant, but it's all quite confusing, and we haven't got time or maybe the interest to go into that today, so I don't propose to do so. And if you want to forfeit for a breach of a covenant, then the lease must contain a re-entry clause, and in any event, I suggest a well-drafted lease should have one. And there's a particular restriction on forfeiting for breach of covenant imposed by section 146 of the 25 Act, which I'll come on to. And then there's a breach of a condition. Now, whether or not a term is a covenant or a condition is quite a contract law question of construction. Is it a fundamental term going to the heart of the transaction? So all of your contract law principles apply here. Generally, if there's a breach of a condition, you don't need an express re-entry clause, but I would suggest you always do include one in any event. And then in terms of how to actually forfeit, there's two ways: peaceable re-entry and proceedings. Now, the term peaceable in the re-entry relates to peaceable to the person. You're not going in there threatening violence. That's a criminal offence, as shall be addressed. But you are allowed to use some force to the property itself, but not excessive force. You can change the locks, and you need to have some unequivocal act to show this. So if you're going to physically re-enter, it's usually done by changing the locks, or if the land is open, having some other means of preventing access to that land. And for the reasons and the restrictions on peaceable re-entry, it generally only applies to, or should wisely apply to, commercial property, and happens after hours or perhaps over the weekend when you're less likely to find someone in the property. And then you have court proceedings being the generally more advisable and more common way of forfeiting. And that, like all possession proceedings, is governed by Part 55 and the practice directions. So the restrictions regarding peaceable re-entry under Section 6 of the 1977 Criminal Law Act, any person without authority who uses or threatens violence to secure entry is guilty of an offence. If someone's on the property, on the premises opposed to the entry, and the person using or threatening violence knows that's the case. So don't do it. A bit risky. But interestingly, that there's a criminal offence arguably committed doesn't invalidate that entry as an act of forfeiture. That's an interesting civil criminal distinction there, or interesting to me at least as a property barrister. Furthermore, where premises are let as a dwelling, it's unlawful to exercise a right of re-entry other than by court proceedings, except where when any person is residing in the premises or any part of them. That's the 1977 Act as well, Section 2. And furthermore, this applies to commercial premises, that is this Section 2 from Eviction Act points, even when there is some residential element, however small or inconsequential that residential element is. And now that's a decision, I believe, of the Court of Appeal in the Patel case. And in that case, the Court of Appeal held that to ensure an interpretation consistent with Article 8 of the ECHR, Section 2 of the 1977 Act was properly interpreted as applying not only to premises let wholly for residential purposes, but also to mixed resi commercial premises. So be extra cautious of that. Particularly so if there is an unlawful eviction for residential premises, you might have to pay the tenant some damages. And for the avoidance of doubt, this applies primarily in relation to England, given the England-Wales distinction following the 2016 Act. And then we have the more common, less risky, in theory, approach to forfeiture, that is by proceedings. So CPR Part 55 applies to both the claim for forfeiture and also any claims from forfeiture. So it's your one-stop shop, as it were, read against the white book to clarify what it actually means. And furthermore, the PD 55A, parent 2.4, specifies what should be in your particulars of claim if the residential forfeiture. So don't get caught up on some procedural points. CPR rule 3.10 can't waive everything. Please try and comply with that. And you can issue in either the High Court or the County Court, depending on the usual circumstances. And this, which court you issue in, does have implications for relief. And I believe this will be addressed later on this evening. And so when the proceedings are served, the lease is treated as forfeit, but only terminates once the court makes judgment. And this in-between period is called the twilight period, hence the potentially picture of a twilight on the stock images. That's Twilight, and that came up along with the Stephanie Meyer books, and I thought this one was more appropriate. And so if the claim fails or the relief is granted, the lease retrospectively is reinstated. And there are some important practical implications from this twilight period, as outlined in those two cases there. So once the landlord is elected to treat it as at an end by serving proceedings, the landlord cannot rely on any breach of the tenant's covenants committed after the date of service. And this comes to my later point, if you can, forfeit, should you? And then from the tenant's perspective, the tenant hasn't elected to forfeit, that was the landlord's choice. And so from their perspective, it was held later on that After service of the proceedings, the tenant could enforce the landlord's repairing covenants since those remained in existence and were enforceable pending the outcome of the tenant's application for relief. So again, don't advise your landlord that you can do whatever you want because they're no longer binding. Just be careful. Further, I guess from that twilight point, it follows that in the interim gap, that the money that you receive in consideration for their occupation is no longer rent, it's mean profits. Even though mean profits are often calculated by the same way as calculating rent, but the nomenclature is different. So bear that in mind as well. And so if we're in the case of a breach of covenant, as opposed to a breach of condition, or non-payment of rent, which has got a separate, at least arguably separate regime, then section 146 of the LPA needs to be complied with. You have to serve a notice under this section in order for the right to forfeit to be activated, as it were. And the language of the section is on the slide for you now. And it's important to notice that the notice itself has to be drafted properly. You have to specify the particular breach complained of, that is, detail the facts that you led you to believe that there has been a breach. Don't just say breach of clause 517. Specify the facts which, on your case, are a breach of that clause. Further, if that breach is remediable, you have to state that you require the lessee to remedy that breach. And also another line stating you require them to make compensation in money for the breach. And so if the lessee fails within a reasonable time thereafter to remedy the breach, if it is remediable, then the notice takes effect and you can forfeit. But it's important then that you provide a reasonable time to remedy the breach, and bear in mind if the breach is remediable or irremediable. And so we have there a Court of Appeal decision in which it gave 3 not mutually exclusive ways of conceiving of covenants. That can be a positive or negative, to refrain, to do, to not to do. There's your remediable and irremediable for section 146 purposes, and your continuing versus once and for all breaches, more relevant to waiver, which we'll come on to. And whether or not a breach is remediable or irremediable is held to ultimately be a fact-specific question. Notwithstanding the foregoing, the courts have held that a breach of a covenant to assign or sublet without consent is always irremediable, and that is in the Scala House decision. There's also some discussion of whether or not using a property for immoral or improper purposes is also irremediable, on the case that once a property has been blemished or its reputation is brought into disrepute, then you cannot recover from that. And so even if the improper purpose is no longer ongoing, the breach is still irremediable. But I think that's open to argument on the facts. And bearing in mind this requirement in section 146 to specify a time, and the sometimes doubtful question of is it or is it not irremediable, it's advised that the notices be drafted as insofar as it is capable of remedy, it be remedied within X amount of time, so that you can be clear on that. But even if you are being cautious and including that language, you still need to give a time which is reasonable for the tenant to consider their position or remedy the breach. If you want to see more on that or more examples of this, again, fact-specific question, I suggest you go to Woodfall. The paragraph reference is on the slide. But in the case of Hopley and Tarvin Parish Council, it concerned an alleged breach of the covenant to keep allotments in good heart, whatever that means. And it turns out that because the soil in that location needed more time than 6 months, 6 months to remedy that was insufficient. So there's some quite interesting cases on that, but Hopley is advised. And then there's forfeiture for non-payment of rent. So in this instance, you cannot forfeit non-payment of rent unless the reservation of rents is a condition or there's an express proviso in the lease, as we've just seen in that practical law example, giving a right to re-enter and determine for non-payment of rent. And in this question, you need to look to the definitions in the lease. What is reserved as rent? In a commercial lease and equally residential, is there a service charge for the building? Is that reserved as rents? Are there insurance rents also? If the tenant hasn't paid some of that, but they have paid their annual rent or their ground rent, according to that lease, is that reserved as rent? And that should be considered when deciding whether you have to go down section 146 or you use the clause or any of the above, depending on the facts of your lease itself. Because if there is non-payment of rent, then there's no need to serve section 146. And that's expressed in the Act itself. And for non-payment of rent, there's a particular regime to be aware of for relief, and that'll be addressed later. And there's the knotty issue of, if I'm considering forfeiting on the circumstances, should I accept rent? Should I demand it and then not take it? Should I return the checks? That's also a complicated point, which I hope will be discussed. If not, it's in Woodfall, or you can ask us to advise. And then I suppose the final point is, if you can, should you? And this is a commercial decision for the client ultimately, but you can advise on the pros and cons of deciding to forfeit if, in your learned opinion, the right to forfeit has arisen. Is it in their interest to do so? Is there a depressed economic climate? And if you think you can forfeit in residential, be really careful to check that you can, or that it's not excluded, or that you do it in the correct way. And here are some factors to be considering, in my opinion, before deciding whether or not to elect to forfeit. And the picture on the slide is Gordon Ramsay's pub, which has recently been taken over by squatters who claim to have an agreement with the landlord. I wonder now if they're still trespassers, but that's what BBC News said. And so then there's benefits of having a tenant in a property. You'd hope there'd be no risk of trespass if someone's in there. And if someone's in there, then they're paying business rates. You hope they're paying insurance. The covenants are still alive, so that you've got someone there who's taking care of the property. And there's a risk to your client if they, as landlord, have got an empty, vacant property there. Although if it might be forfeit, and if the landlord wants to redevelop, this could be a good chance to do that. And so these are some factors to bear in mind when advising if you can forfeit, should you?
Thank you very much for that, Sophie. There were a couple of questions that came in while Sophie was talking. We'll take those at the end. So Kim now is going to talk about waiver of forfeiture. Kim is a specialist property and planning practitioner with particular expertise in the overlap. She does the full range of property work, frequently advising on forfeiture matters, both residential and commercial property types. And her recent cases in this area have included acting with Miriam Stacey on a claim for possession of a very large former munitions site in Cumbria, which has raised numerous issues in relation to the nature of forfeiture clauses, waiver and relief, advising on a forfeiture claim. The tenant was served with a notice under the Leasehold Property Repairs Act 1938, which Sophie dexterously dodged, advising on the question of when the right to forfeit arose under the terms of a lease in order to establish whether the right to forfeit had arisen by the date of an act of waiver. So over to Kim.
Thank you very much, Tim. Thank you all for being here. So I'm going to cover, as Tim has said, waiver of forfeiture, and specifically starting with what is waiver, and then looking at the legal ingredients that make up waiver by the landlord, followed by the effect of waiver, and then the interaction between waiver and statutory preconditions for forfeiture in residential long lease context, because there's sort of an interesting interaction there, and then a few practical tips at the end. So starting with what is waiver, the really important thing to remember about waiver is that it's where a breach of covenant or other event has occurred, giving rise to the right to forfeit. The landlord is put to his or her election as to what to do. They may choose to enforce their right to forfeit that's arisen and thereby treat the lease as having come to an end, or not to enforce that right and to treat the lease as continuing to exist and perhaps seek a remedy against the breach in some other way. This is just like with any other contract where you've got a fundamental breach of contract. Do you treat the contract as continuing, or do you treat it as being repudiated? And waiver is the idea of what happens when the landlord treats the lease as continuing to exist and therefore is deemed to have taken that election and waived the right to take the forfeiture route. So it's really important to remember that waiver of the right to forfeit is not the same as waiver of the breach altogether, and the landlord will still have very likely other remedies that they can choose to pursue in respect of that breach, for example, seeking specific performance of a covenant or damages, or a money judgment for non-payment of rent, for example. And it's generally much harder for a landlord to waive the breach altogether, because that depends on a finding of consent to the breach, which is different to waiver of forfeiture, which, as we'll come on to discuss, can be a lot easier for a landlord to do accidentally or intentionally. So, having said that, what are the legal ingredients of a waiver? There we go. So waiver can only occur where the landlord has knowledge of the facts upon which their right to re-enter has arisen, i.e. knowledge of the breach or other event giving rise to the right to forfeit. And with that knowledge, they do some unequivocal act, recognising the continued existence of the lease, and unequivocal is important there. And then that act or recognition is communicated to the tenant. So those are the three fundamental ingredients. Skipping backwards and forwards. So a simple example, the landlord knows that the tenant has failed to pay rent that's fallen due for the first quarter of the year, and the landlord is entitled under the lease to forfeit in respect of that non-payment of rent. The landlord, knowing this, nonetheless demands rent for the following quarter and accepts that rent. They've therefore, having done that, they've waived the right to forfeit in respect to the failure to pay the Q1 rent. But that's a simple example. Obviously, things get a little more complicated in practice. Let's look at each of those in a bit more detail. So, landlord's knowledge, first of all, first ingredient. Put simply, a landlord can't make an election of whether to forfeit the lease or not until they're aware that that right exists. So in most cases, the landlord must have knowledge of both the facts giving rise to the right to forfeit and of their right to forfeit itself. Importantly, however, it's not always the case that the landlord has to have actual knowledge. That knowledge can also be imputed. So, for example, knowledge acquired by an employee or agent of a landlord, such as a porter in the building, a managing agent, or even a solicitor. Unless, and that's an important caveat, in terms of employees or agent, the scope of that agent is limited and they have no duty to report the breach of covenant to the landlord. The fact that information is in the public domain will not necessarily be sufficient for that to be imputed to the landlord. It will depend on the facts of the particular case in question. Of course, if a landlord can be shown to have actual knowledge of information that's in the public domain, then that takes the question of imputation out of it anyway. But the Parway Estates case that's there was a case of insolvency of a tenant that gave rise to the right to forfeit, that was advertised in the London Gazette, as insolvency often has to be. And it was found by the court there that that did not mean that publication in the London Gazette was not designed to bring it to the attention of a landlord. It was for other purposes. And on the facts of that case, it wasn't to be imputed that the landlord had knowledge of the insolvency as a result of that. Importantly, you have to distinguish knowledge from suspicion. So, for example, if a landlord suspects that there's been a subletting in breach of covenant, but is assured by the tenant that no such subletting has occurred, then they won't be found to have knowledge. They suspected it, they took some action to try and find out about that suspicion, and the tenant told them that it was fine. That's okay. However, the landlord should always take reasonable steps to establish the truth or falsity of their suspicions. And the Van Harlem case is quite an interesting one. The tenant had been committing criminal acts in breach of the Official Secrets Act from the property, and his arrest was a matter of public knowledge. It had been well publicised, I think, on the local news. And the landlord knew that he was alleged to have been a spy, exciting case, as far as forfeiture goes, but did absolutely nothing further to investigate those facts, and proceeded to demand rent, having that background knowledge, and that was found to be a waiver because he was imputed to have known that there had been a breach of covenant through the criminal activity in the property. What about constructive knowledge? So that's where a landlord is put on inquiry but doesn't choose to sort of pursue those inquiries. It's a bit like the suspicion sort of case. The case law on this is inconsistent, and I've put the two sort of conflicting authorities there on the slide, probably one to be determined down the line. If you think that you're in a situation where the landlord knows something, again, I think it's probably always just worth making those inquiries before you do anything that could amount to a waiver. It will always be a fact situation specific case, and I think, as I'll keep coming back to throughout this talk, it goes back to that principle of election. Does the landlord have sufficient information on which they can be making a choice as to whether or not to exercise the right to forfeit or to treat the lease as continuing? The burden of proving this, however, will ultimately fall on the tenant. Right, next step, an unequivocal act. There we go. An unequivocal act. So lying on your sofa doing nothing, you're going to be okay. You're probably not going to waive the right to forfeit. But the act relied upon as constituting waiver must amount to a recognition of the continued existence of the tenancy. And in the case of Stemp that you've got there on the slide, the tribunal put it quite succinctly as follows. The act must be so unequivocal that, when considered objectively, it could only be regarded as having been done consistently with the continued existence of the tenancy. So generally, sitting back, witnessing the breach will not amount to waiver. You have to then do something about, well, something that recognises it. However, as always, there's a caveat. In some cases, and this is a very old authority, but it's remained good law, long and continued acquiescence in repeated breaches may amount to waiver. So you're going to need to be careful in those kinds of situations where something's been going on for a really, really long time, that you're not sort of getting to a point of waiver by doing nothing. Generally speaking, you're looking for a positive act by the landlord. So let's have a look at a few examples. Maybe not. So a few examples. Cases where waiver is usually going to be found: demand and acceptance of rent, which has accrued due after the date on which the right to forfeit arose. That's always going to be a waiver of any breach that's occurred prior to that date, even if you accept the rent on a without prejudice basis or under protest. So the only exception to this is there's a strict position generally. The only exception is in the case of certain statutory security of tenure cases where you can accept rent subject to a caveat, but that's very, very specific. Please look into those cases if you think that you're in that category, or come and speak to someone about it, because generally speaking, default position, don't accept the rent if you want to pursue forfeiture. Distress or use of commercial rent arrears recovery procedure will also be a waiver. Again, these are all things that depend on effectively treating the lease as continuing. You can only use the commercial rent arrears recovery procedure if there's a tenant. That implies that there is a lease. Similarly, a claim for breach of covenant, including rent arrears, is obviously going to be dependent on the existence of a lease. The caveat to that, and the reason it's got an asterisk by it, is that if you are making it in the alternative, to a claim for forfeiture. So if you're bringing a claim for forfeiture, you might have a claim for breach of covenant in the alternative. That's okay. Or if you are bringing a claim for breach of covenant pursuant to a statutory requirement. So for example, in the long leasehold context, if you want to bring a claim for forfeiture, you have to first establish that there has been a breach of covenant. That's a requirement under the long residential leasehold context, I should say. That's under Section 81 of the Housing Act 1996. So obviously going to get to determination that the service charges are payable in order to then be able to serve Section 146 notice is not going to waive your right to forfeit because you're doing it as a precedent step to serving that 146 notice. Other reliance on covenants in the lease. So for example, requiring the tenant to carry out repairs. Again, you're treating the lease as continuing. That is very likely to amount to a waiver. Service of a notice to quit. Again, depends on the terms that depends on there being a lease in place. It's different to terminating through forfeiture. So that will, per the case that's on the screen there, usually amount to a waiver. Another slightly unusual example, but again, an offer by a landlord to buy the tenant's interest. So it comes back to this doctrine of election. You know, if you're buying the tenant's interest, it's just that there is an interest to be bought, and that did in that case amount to a waiver. Where will they not be waiver? Service of a Section 146 notice, obviously, because that's a prerequisite, as Sophie's explained, in cases of breach of covenant to exercising the right to forfeit. So it would be a bit harsh if it amounted to a waiver. Acts done after an unequivocal claim for possession has been brought. Once you've served your proceedings and you've started to seek forfeiture by proceedings, then you're okay. Engagement in without prejudice discussions generally, that's fine, but it's just the acceptance of rent on a without prejudice basis that is problematic. But you can obviously try and engage in WP discussions to avoid the need to go to court or to forfeit the lease, as long as you're very clear about those, as you would be in any case. And then interestingly, in this case, so if you send, it sounds like this is a very specific, fact-specific case, but it just shows you don't always have to stop doing any interaction with the tenant whatsoever. In the expert clothing case, sending an engrossment of a deed, a variation for execution by the tenant that had been agreed before the right to forfeit arose wasn't sufficient to amount to a waiver. But I mean, outside of a clear case of a demand for acceptance of rent, the court is free to look at all the circumstances of the case. And you're applying the tests that I've set out in the previous slide of, is the landlord treating the lease as continuing? That is the fundamental question that you have to consider and that the court will consider on the facts of the particular case. There are a couple of other points to note when it comes to the act. Intention to forfeit is irrelevant. So if you accept rent by mistake because you've forgotten to cancel an automatic or to include a direct debit or something from coming in, that can amount to waiver. So landlords have got to be really, really careful if they're at a point where they know a breach has arisen. And you often hear of landlords freezing accounts and putting things on hold and making sure that all of that is stopped. And contractual clauses seeking to prevent waiver are likely to be ineffective. The expert clothing case is the lead authority on that in this jurisdiction. And that's because it comes back to this foundation of waiver being an election, and it's inconsistent to both treat the lease as being at an end, but also relying on a clause in the lease as preventing waiver. That's sort of an inconsistent approach. However, there are a couple of cases to the contrary in Australia and New Zealand. So there might be scope for a Supreme Court fight on that one day if anyone fancies taking that up. Looking at communication then, which is the third ingredient of waiver. So an act of waiver has to be communicated to the tenant in order to give rise to a waiver. The opposite, where I put it on the slide, an act of waiver which is not communicated to the tenant does not amount to waiver. So for that reason, if the act of waiver that you're relying upon is sending a document, the waiver is not going to be effective until that document is received by the tenant and therefore communicated to them. Not much more to say on that one, but just worth remembering that anything the landlord does internally is not going to be an issue. It's only when the landlord becomes aware of it that we have a problem. So what's the effect of waiver? The effect of waiver will depend on whether you have a once and for all or a continuing breach. So you remember that's one of the categories of breach that Sophie mentioned from that court decision. Where a once and for all breach has occurred, then waiver will preclude the landlord from ever forfeiting in respect of that particular breach. So you've got some examples. There are some examples on the slide of what a once and for all breach might be. So rent arrears for that particular period. Obviously, rent will continue to be owed, and each time new rent arrears accrue, that is a new potentially right to forfeit that's arisen. Assignment and subletting has been found to be a once and for all breach. Failure to carry out repairs by a specified date. Obviously, that's different from a failure to keep the demised premises and repair sort of generally, that which can be an ongoing obligation. Alterations to the property without consent, or a covenant that requires an act to be performed within a specific time. Once that's been breached, that's a once and for all breach. Continuing breaches obviously do what they say on the tin. So a new right to forfeit will arise in respect to the breach each day. And so waiver is going to be less problematic in respect of a continuing breach for obvious reasons, because you'll get a new right and therefore that one won't have been waived. Examples of that, as I've said, failure to keep the demised premises in repair generally, as distinct from failure to carry out a repair by a specific date, or use of the premises in a prohibited manner. The one thing to bear in mind, though, with a continuing breach, obviously you'll often be in a situation where you would rather find a continuing breach if you think you're at risk of having waived the breach. But where that continuing breach is integrally bound up with a once and for all breach. So a typical example of that is if you have an unlawful assignment for use in a prohibited matter, in a prohibited manner, even though use in a prohibited manner is a continuing breach, it's fundamentally tied up in the once and for all breach of having sublet. And therefore any waiver of the first, the once and for all breach, will also be likely to waive the continuing breach. And that's what happened in the Downey and Turner case. So you can't always pick and choose your breaches in a way that might be convenient to avoid a waiver argument. Finally, then, this point about waiver and the statutory preconditions to the forfeiture stamp case, just because it comes up a lot in residential landlord and tenant context. There are various restrictions, and I've touched on one of them on forfeiture in the residential context. For example, under section 168 of the Common Hold and Leasehold Reform Act 2002, you can't serve a section 146 notice, which Sophie was talking about, in respect of a breach of covenant in a residential long lease case until you've had a determination of that breach or an admission of it by the tenant. And similarly, under section 81 of the Housing Act 1996, you can't exercise a right of re-entry in respect of a failure to pay service charges until you've had a determination of that those service charges are payable, or again, an admission of the same by the tenant. So as you can imagine, those steps can sometimes take quite a long time to complete. And therefore it can be quite a long time before the landlord's entitled to exercise the right to forfeit that has arisen. For example, getting a determination of payability of service charges in the tribunal. I'm sure anyone who's been involved in that knows it can take quite some time. And one of the questions that arose for determination in the Stemp case was whether the landlord could waive the right to forfeit before those steps had been completed, and therefore before it actually had the right to exercise, before it could actually exercise that right to forfeit, because it was still precluded by the statutory preconditions. And perhaps surprisingly to some people, the upper tribunal's answer to that question was yes. I think the more I think about it, I think legally it's the right answer. Practically, it puts landlords in quite a challenging position. But at 71 of his judgment, His Honour Judge Huskinson said that, and it's quite, I should have put it on the slide, but you've got the reference there. It's quite useful to think about the reasoning. But he said that there's various statutory fetters upon a landlord's right immediately to forfeit a lease for breach of covenant. Where a landlord knows of the facts upon which a right to re-enter arises, I see no difference in kind between the position of such a landlord if the right immediately to exercise a right to re-enter is constrained by a need to comply with section 146, which Sophie talked about, or by a need to comply with section 81 of the Housing Act, so that's the service charge provision, or 168 of the Common Hold and Leasehold Reform Act, so that's the breach of covenant condition. In each case, the landlord knows the facts upon which the right to re-enter arises, and in each case, the landlord is not yet in a position to exercise that right because the statutory procedures have not yet been worked through. Where the breach of covenant is irremediable, it is not the law that a landlord is unable to waive a right to re-enter because a section 146 notice has not yet been served or has not yet expired. So by parity of reasoning, I reject the submission that a landlord is unable to waive a right to re-enter because some other fetter upon exercising a right to re-entry in an irremediable breach has not yet been worked through. So the important thing is that his reasoning is by reference to section 146 in general, and also that it only appears to apply to irremediable breaches. Where you've got a remediable breach, the position may of course be different. So in those cases, you've got to be careful that despite the length of time that a landlord might be waiting to get the determination that they need to serve a section 146 notice or to proceed with the forfeiture, that entire time there's a risk of waiver. And so you need to be really careful that you're not doing anything in that period that might give rise to a waiver. And the context in which this often arises, and that is the context of the Stemp case itself, is actually cases where landlords aren't necessarily thinking about forfeiture in the first instance. They've gone down the route of getting a determination that service charges are payable, or that there's been a breach of covenant. And then they're trying to rely on a cost provision that says that they can recover costs of forfeiture proceedings or serving a section 146 notice. And that's what happened in Stemp. And they said, well, you can't rely on that provision because you've waived the right to forfeit ages ago. And therefore you can't possibly be doing this as a prerequisite to forfeiture because forfeiture has gone out the window. And that leads me on to a couple of practical points just by way of summary. So if a client comes to you and for advice about breaches of covenant or non-payment of rent, and make sure you've got those alarm bells ready to go in your head of is forfeiture an avenue that the client wants to pursue in relation to this? And if they do, make sure that they're putting suitable procedures in place to avoid waiver as a result, assuming it's a once and for all breach. It's also worth assessing whether any communications or actions to date may have already amounted to a waiver, because that could, of course, affect your strategy going forwards. And when you're asking those questions, it's just coming back to this simple point of waiver is based on election. That's a really helpful sense check. Am I or the client doing something that relies on the lease continuing to exist? And even if forfeiture is not an avenue that the client wants to pursue at that stage or that they're talking about, it's always worth keeping waiver in the back of your mind, because it could be a good tactic to have forfeiture up your sleeve and you don't want to waive by mistake. But also there might be a cost provision, as in the Stemp case, that requires forfeiture to still be on the table. And if that's your only way of recovering costs, for example, in a service charge dispute before the tribunal, you might want to keep that option open to you. The other flip side to that is that there are obviously going to be more complex premises, and the case that Tim mentioned that I was working on with Miriam Stacey is an example of that, where you've got really large premises with quite intensive repair obligations or all sorts of things that have to be carried out by the landlord, by the tenant. Freezing anything and avoiding any action that could amount to a waiver can be quite difficult, especially for a long period of time, and can result in poor management of the property or all sorts of complications. So it is worth, in those kinds of cases, firstly thinking about whether forfeiture is something that you're seriously considering, and so whether it matters. But if it does, can you have some kind of without prejudice interim arrangement that doesn't rely on the lease continuing, but allows you to take some practical steps in order to keep the property being managed at a minimum for a sort of lengthy period of time where proceedings might be ongoing. And that's everything that I had to say on waiver. I'll hand over to Harley for relief.
Thank you very much, Kim. Our next speaker is Harley Ronan, who has a practice encompassing all aspects of law relating to the use and development of land, often instructed in landlord and tenant matters, and appeared in the Supreme Court led by Justin Bates in an appeal about the right manage under leasehold, Common Hold and Leasehold Reform Act 2002, and he's a member of the editorial Encyclopedia of Housing Law and Practice. Over to you, Harley.
I can also beat Sophie's tour in the County Court of England and Wales this week, having appeared or intending to appear in the County Court every day this week, including in an application for relief from forfeiture in Wales. So I am ticking all of the boxes. Okay, so in trying to bring a thread through the talks we've had today, we've had an overview from Sophie about how forfeiture can be affected. We've had talk from Kim about how the landlord might lose the right to forfeit by waiving a breach. And in my talk, I want to focus on the situation where the right to forfeit has not been lost. So the landlord has the ability to effect a forfeiture, whether that's by service of proceedings or by peaceable re-entry. And you'll remember that Sophie said electing to forfeit can be achieved by either of those two methods. What can the court then do to avoid the forfeiture from actually taking place? And just for anyone who's approaching this for the first time, when we're talking about relief from forfeiture, i.e. when a lease has been terminated, the court has various jurisdictions to relieve from forfeiture, i.e. order that the lease continues. And that is what is known as granting relief from forfeiture, just so we're all on the same page. I need to speak to whoever has organised these talks, because I have definitely been given the most knotty of all the talks, in my opinion, because in general terms, the precise jurisdiction that's in play on a particular application for relief from forfeiture, and in particular, the principles that govern the exercise of the discretion, indeed, whether there is a discretion at all, vary depending upon, firstly, how the lease was forfeited, the reason for the forfeiture, and the court that you're in. So, forgive me, I'm just going to, sorry, I should have gone to that slide originally. So the court has various jurisdictions to order that a forfeited lease shall continue. But before I go into that myriad of various jurisdictions and principles that are in play, I really just want you to have two propositions in mind throughout the time that I'm speaking. And the first is that the right to forfeit is regarded by the court as security for the performance of the tenant's covenants. Second proposition I want you to have in mind when thinking about relief, regardless of the principles at play and the jurisdiction at play, is that if the landlord can be put in the same position as if the breach and the forfeiture had not occurred, in general terms, the tenant should be granted relief. And that's not an immutable principle, as we'll see, but it's just worth bearing that in mind when looking at the statutory scheme, and in particular when advising clients. So let's go into how relief operates in the various ways. I'm afraid that's easier said than done. And I've made this table really just to scare you in the first instance, but really because I couldn't think of a better way actually of conveying how, depending on the breach, depending upon the method of forfeiture, and depending upon the reason for forfeiture, there are various routes to how you actually get an order from the court to grant relief from forfeiture. And in general terms, there's two variables at play that are going to be relevant for any application for relief from forfeiture when you're trying to determine which court you need to be in and which principles will govern whether or not your application will succeed. The first is venue, county court or high court, and the second is whether the breach of covenant is for non-payment of rent or for some other covenant under the lease. If you're in the county court and you're forfeiting for non-payment of rent, you're in the County Courts Act 1984. If you're in the county court for a breach other than non-payment of rent, your application is going to be governed by the Law Property Act 1925, section 1.6. If you're in the High Court for non-payment of rent, there's no less than 3 jurisdictions. You've got the Common Law Procedure Act of 1852, Senior Courts Act, and an inherent equitable jurisdiction. If you're in the High Court for other breaches of covenant, you are in the regime for the Property Act again, and if for some reason you might not be within that statutory jurisdiction, the High Court also retains a residual inherent jurisdiction. So I want to divide this talk into two parts. I think that's a sensible way of doing it. Firstly, I want to go on to breaches of covenant other than non-payment of rent. And secondly, I'll deal with non-payment of rent separately because it's own bespoke jurisdiction. So breaches other than non-payment of rent. Well, happily, this is probably the easiest part of the talk. Whether you're in the County Court or the High Court, or whether you intend to apply in the County Court or the High Court, the principal jurisdiction is the same, and that's section 1462 of the Law of Property Act, which governs the jurisdiction by an application for relief from a tenant. So section 1462, and I'm not going to read it out loud, provides that where a landlord is proceeding to enforce a right of re-entry, the tenant may apply for relief and the court may grant relief as it sees fit, having regard to all the circumstances of the case. And critically, it may grant relief on conditions as to the payment of costs, damages, etc., again, as it sees fit. 3 points to note about this. I want to stress really. The first point is that phrase by action or otherwise. So the court has jurisdiction to grant relief where the forfeiture is by the service of proceedings, but it also has jurisdiction to grant relief where the landlord has peaceably re-entered. So peaceably re-entering doesn't avoid the court's jurisdiction to grant relief under section 142. Second point to note is that it's a very wide discretion indeed. It uses that term as the court thinks fit, both in regard to whether relief should be granted and, of course, the conditions that might be imposed. And the third point to stress is that relief may be granted on terms, including the payment of costs to the landlord and terms requiring the tenant to remedy the breach in question. So let's start with the principle or whether or not relief should be granted. What is at play when the court is considering whether or not to grant relief? There's no universal rule as to the application of the power, unfortunately. Each case is going to turn on its own particular facts. But that proposition I asked you to have in mind, the general overarching proposition that guides the court's discretion is that if relief can be granted on terms that put the landlord back in the position as if the breach and the forfeiture had not occurred, generally relief should be granted. Particular factors of relevance are really endless, but in particular, I wanted to highlight the nature and the gravity of the breach. So a particularly serious breach is obviously going to be something that militates against relief being granted. Harm caused by the breach and the relationship to forfeiture. So if you've got a relatively trivial breach that hasn't caused significant harm, that's going to be a factor that militates against the court granting relief. Willfulness and attempt to the remedy breach are very important. I did a case, I can't remember if it was this year or last year now, in which a landlord forfeited a lease for various breaches of covenant, didn't breach for non-payment of rent, but had actually obtained a money judgment for about £100,000 for non-payment of rent. And on the tenant's application for relief from forfeiture, the tenant put in the witness statement saying, I will pay those arrears if relief is granted. So payment of the money judgment was conditional upon relief being granted. And I had various clever arguments as to why, or I think they were, as to why relief should not be granted based on remediability of the breach, various planning points thrown in. Fundamentally, the point that stuck the most in the judge's mind was that that tenant came to court and said, I will pay that money if you grant relief. And that was a very powerful factor in that judge's decision as to refuse the application. Delay is very important as well. The court generally expects people to act quickly in these situations, in particular because landlords acting reasonably might grant a tenancy to a third party, they might want to sell, so on and so forth. Windfall is relevant. So again, it comes back to proportionality. If you've got a £1 million lease being forfeited for a relatively trivial breach, if you've got 999 years left on that lease, that is going to be a factor that militates against relief being granted. And third-party interests are also relevant to the exercise of the discretion. So if a landlord has in fact gone to a lease to a third party after a forfeiture, that is a relevant factor to consider when the court is considering the application. So who can apply? Well, the tenant, most obviously, under section 1462. But there is case law to suggest that where the tenant has assigned in breach of the lease and are therefore not the tenant anymore, they can nonetheless make an application for a relief. Subtenants can apply under section 146. In particular, it's got its own section under 1464. The principles at play when a subtenant applies are the same essentially as I just outlined, but there is an added factor, which is that if the court grants relief to a subtenant, the effect of that is to effectively force the landlord to enter into a new lease with a third party. So there's a added caution, I suppose, when the court is considering that type of application. Mortgagees can apply. Party under an agreement for lease can apply if they can compel the grant of the lease. If the lease is held by joint tenants, all joint tenants must apply. And there is case law as well to suggest actually that licensees with possessory rights can also apply for relief, which is obviously difficult to square with relief being a proprietary remedy. So when can an application be made? I said, well, I emphasised the terms of section 146, and I've reproduced some of it there. Where the lessor is proceeding, so where the landlord is proceeding by action or otherwise to enforce the forfeiture, an application for relief can be made. The landlord is proceeding as soon as they've served a section 146 notice, so before any forfeiture has in fact been effected, an application for relief could be made. If the forfeiture is by the service of proceedings, an application for relief can be made any time until a possession order is enforced. And if the forfeiture is effected by the landlord re-entering, the landlord is proceeding so long as they remain in possession of the demised premises. So in theory, a landlord, there is no hard time limit if a landlord peaceably re-enters. But in practice, the court expects people to act with reasonable promptitude in seeking relief. Terms, I've mentioned terms and that the court can grant relief on such terms as to costs, expenses, damages, etc., as the court thinks fit. And again, that proposition, the terms of relief ought to put the landlord back in the position as if the breach and the forfeiture had not been effected. And in almost all cases, that is going to require the payment of the landlord's costs by the tenant, usually on the indemnity basis. There's not really an authority which says you're entitled to costs on the indemnity basis as a matter of law, but invariably that is what the court will order. But you could have other terms of relief. So, for example, if the breach in question was unauthorised alterations, the terms of release might be to undo those alterations. The effect of relief is that the tenant holds the properties if the lease had never been terminated, and any derivative interests, so any subtenancies, will be reinstated as well. Right, that was the easy bit in many respects, because when you are forfeiting for non-payment of rent, a different regime applies, and it's rather more technical. And I want to begin with section 138 of the County Courts Act. Section 138 applies where the landlord is seeking to forfeit a lease for non-payment of rent by a claim in the county court. And under section 138, critical point to note is that the tenant has two automatic opportunities for entitlement to obtain relief. It's not a matter of discretion for the judge. So the first opportunity the tenant gets to obtain relief from forfeiture is that if they pay all of the rent in arrear and the costs of the claim not less than 5 clear days before the hearing, the claim will end and the lease will be reinstated. If the tenant doesn't do that, and I've seen lots of cases when they don't do that, I don't understand why, because it's a very easy way to avoid relief. If they don't do that, and you go to a hearing, the court is satisfied at that hearing that the claimant is entitled to enforce their right of re-entry. Court doesn't have any discretion but to order possession. But the time for possession needs to be at least 4 weeks from the date of the order. So that's the minimum time for possession. And critically, the order must make provision of automatic relief from forfeiture if the arrears and the costs are paid. And there's a prescribed form in N27, which is very useful to look at if you're trying to understand how that wording should actually take effect. 2 points to stress on that is that the court doesn't have any jurisdiction, this is the county court, doesn't have any jurisdiction to make a different order. It has to contain that provision. And if it doesn't, it can be set aside as of right. Second point to note is, and I think there's a typo in my slide there, is that the time for possession in the order and the time by which payment must be made to obtain automatic relief can be extended by the court any time up until the land is recovered by the landlord under the order. It doesn't end there. If the landlord enforces their order, they recover possession. Section 139 of the County Courts Act applies, and the tenant may make an application for relief at any time within 6 months from the date on which the landlord recovers possession. The principles at play, though, are slightly different. It's not an automatic entitlement to relief. It's more akin to Section 146 discretion in that you see that phrase again. The court may, if it thinks fit, grant to the tenant such relief on such conditions as it thinks fit. The effect under Section 138, just like under Section 142 or 146, is that the tenant will continue to hold the same lease. There won't be a new lease. Who can apply? A tenant, obviously, but Section 138(9)(c) says a person with derivative interest can apply as well. So that's a situation if you are seeking to forfeit a lease for non-payment of rent in the county court. Section 138 is the only provision you need to know in those circumstances. But if the landlord peaceably re-enters, the provisions in Section 138 as to automatic relief are not engaged. So the tenant doesn't get that 3 bites of the cherry. That doesn't mean there's no jurisdiction for the court to grant relief. So under Section 139, if the landlord has re-entered, the county court has relief to grant, so it has jurisdiction to grant relief upon the tenant's application following the re-entry. Application has to be made within 6 months of the date of re-entry, and the county court may grant relief, such relief as the High Court could have done, which is a useful segue into the High Court jurisdiction. And I'm not going to say very much on this at all, actually, largely because given where this seminar series is aimed, I suspect pretty much all of us, with the exception of Tim, are in the county court most of the time. So I wanted to focus more on the county court. But let's just have a quick look at the High Court's jurisdiction to grant relief from non-payment of rent. It's got 3 jurisdictions that you need to be aware of. I'll start actually with number 2, which is a statutory jurisdiction introduced in the 19th century. I'm not going to go through it because I don't have time, but it essentially tried to make provision not dissimilar to the County Courts Act, in that relief could be granted automatically upon the payment of the costs and the rent in arrears. It hasn't been that successful because the High Court retains an inherent equitable jurisdiction, which is my first point, which is that relief in general terms should put the landlord back in the position as if the breach and forfeiture had not occurred. And under that inherent equitable jurisdiction, the court has very wide discretion on the facts of each case, akin to Section 146 really, but guided in non-payment rent cases that the rent arrears must be paid, as must the costs. The third jurisdiction that the High Court has is another statutory jurisdiction, and that is essentially a codification of the inherent equitable jurisdiction. That's my whirlwind tour of the various routes and rules and jurisdictions, but I wanted to end on just some practical points, and Sophie's stolen some of my thunder on this. Okay, so I've talked about when to apply, who can apply. a claim for relief from forfeiture can either be a standalone claim in its own right, or it can be brought as a counterclaim to a landlord's claim for possession. There is a prescribed claim form which doesn't seem to be used very much in 5A, and it's quite useful because it has everything you need, including the particulars on a single document. As Sophie mentioned, claims for relief are governed by Part 55. They do fall within the possession claims regime in the CPR, which means inevitably under Rule 55.5, the court will list the claim for an initial summary 15-minute hearing. And I've had the dubious pleasure of being at court with clients who've not been aware of that and seem to think that their application is going to be determined there and then on the merits on that day. Whereas if you do possession claims, you'll know that the first hearing is essentially to separate out unarguable claims from arguable claims. And if you are coming to court saying, I want the court to exercise equitable jurisdiction, that is not going to be determined in 15 minutes. So in terms of managing clients' expectations, it's important for them to know that that first hearing isn't going to be a substantive determination on the merits. And if you are acting in these type of claims, I think in almost all cases, unless the application is utterly hopeless, it's worth just agreeing directions to vacate that hearing and go straight for trial. 138 claims. So if you're in the county court for non-payment of rent, I put this there again. It's so critical that your order complies with the requirements of the Act, because I've been sent instructions on a number of occasions with draft orders that try and include payment of other sums which are not rent properly reserved under the rent under the lease, and the court can't include, for example, service charges which are not rent, service charge arrears, as a condition of granting relief. So it's really important that you separate those out as a conventional money judgment. Sophie's mentioned this, so I won't go over it again, but you're in the twilight period once you forfeit by proceedings, and during that twilight period, the landlord generally can't rely on the tenant's covenants because they've elected to treat the lease at an end, but the tenant can rely on the landlord's covenants. So I think that's everything I wanted to say about relief from forfeiture. So thank you very much. I'll give that back to Tim.
Well, thank you very much, all three speakers. I certainly found that very educational. I think I've been reminded of more than I ever knew, actually. There are some questions that have come through on the screen. But before we look at some of those, is there anyone in the room with a question that they'd like to ask? If we do it roughly in the order of the speakers, is there anyone who had a question they had in mind for Sophie? Yes?
I've got a question. I don't know if it's something you can answer or not. But I had a case whereby a leaseholder committed sort of antisocial behaviour, which I think is somewhere in the lease. There's some breach in terms of he tried to set fire to another resident's property and he'd been put in prison. But unfortunately, we didn't serve any notices, and the client served a Section 20 notice afterwards to a lot of people in the block. So I'm assuming we've waived the breach. There's nothing much we can do unless there's any further breaches in the future. He doesn't pay the rent.
That sounds a great question upon which you could instruct someone, but if that's more of a waiver question, I think that's more for Kim.
Is it Section 20 notice as in a service charge consultation?
Service charge and some works they need to do.
Yeah. So I mean that sounds to me like a case where, you know, you've probably got imputed knowledge, if not actual knowledge of the breach. It almost certainly is a breach that gave rise to the right to forfeit, unless you've got a very oddly worded lease, I'd have thought. But the service of the Section 20 notice, if it was served on that tenant also.
Yeah.
Although if he's in prison, there's an interesting question of whether he received it and actually whether it's been communicated to him. But I think you'd be a bit in difficult waters, I think, on that one, at least up to that point. And then obviously anything beyond that will be a new.
So we just have to wait to see if any new breaches happen. Yeah.
It sounds like one of those classic examples as well, though, where the service of the notice is predicated on the continued existence of the lease, because why else would you need to serve the notice. It's
Yes.
exactly as you said, it's just,
Yeah.
it's about election.
But it's the communication to the tenant that I think might be
Mm.
interesting, and
Mm.
if they're not there to receive the notice, but it's probably too legally interesting to be practically useful to your client.
Yes, there's a question at the back.
The right to forfeit the breach of condition as distinguished from the breach of covenant. And that's quite interesting. Do you have that example of that? Because obviously, so it goes to half of the transaction fundamentally, because I must admit I've never heard of that before. So
Sort of an example of something that would be a condition, breach of condition rather than a breach of.
Covenants.
Well, the rent is the classic example.
Yeah, because it's,
There are different ways of thinking about why you can forfeit for non-payment of rent. Some have to do with historical leftover about what rent is, something that passes uniquely from the land. A simpler way of thinking of it is that it's a condition of the lease. It's fundamental, and that's why you don't need a specific reservation, usually.
Actually, and why you don't need a section 146 notice if it's for a rent. Well, I mean, apart from that, the statute tells you don't, but.
and then the lease being payment of rent for a period with exclusive occupation is fundamental to what makes it a lease. So that seems to me to be a condition, but you'd be silly not to express it in your forfeiture clause in the lease.
I saw a lease once where there was no forfeiture provision, but there was a provision that said something to the effect that everything in here is a condition. So we were able to say, well, you breached this, you breached a condition, and therefore we're able to forfeit.
That makes it harder, because then if you're saying everything is so important, you can't separate what actually is essential. So I'd argue it's not all conditions.
Luckily,
If you're saying there's 100 covenants.
luckily I wasn't against you in that case.
Yes, they raise these questions, all raise sort of side issues, don't they? What do the courts really mean in this context by condition? Because in point of contract law, you can agree what is going to be conditional or not by using clear enough language, whether or not it would otherwise be fundamental. So we better not have too many questions like that. Yes.
I was going to ask about tenant insolvency events. When you've got a forfeiture clause and it says the right to forfeit will arise if the tenant goes into administration, but there's not an actual covenant that the tenant must not go into an administration. How do you classify those? Is that a case of breach of condition, or it's just the right to forfeit has arisen? And if so, do you actually need to do a section 146 because it's not strictly a breach? Because I feel like you would see a section 146 saying, oh, the tenant's gone into administration, but it's not really a breach of covenant.
Do you need a 146 if you? Your forfeiture clause specifically gives right, if you've specifically got the right to re-enter on an event of insolvency, then that's fine. I think the condition covenant thing aside, but I think whether you'd need a section 146 notice is quite an interesting question.
It would suit moratorium render particular rights in a lease somewhat.
Somewhat a moot point.
Prerequisite step to then getting permission or consent.
And how would you specify a reasonable period in which you can remedy your own insolvency?
Yeah.
And that sounds very difficult.
One to be answered in due course. Unless anyone else has got any.
Should we have some of the online? I mean, the first one to come in was from Josh Millichamp, who asks, where a landlord does forfeit a commercial lease, non-payment of rent, what happens to the tenant's goods and the tenant's fixtures and fittings? I think a point of law, the landlord at that point becomes an involuntary bailee. So there's a duty not to be reckless with the goods and destroy them, but it's not a very burdensome duty. You need to establish whether the goods have been abandoned or not. And there's a procedure under an Act 1977, which you can follow and which should be capable of providing resolution. It's the torts interference, something or other act like that.
Interference with the.
So there is a way of sorting it out. And if the tenant pays the costs of storage and all the rest of it and acts in a reasonable time, then the tenant can have them back. But otherwise, after a lapse of reasonable time, do with them what you want. So I think that's the position in answer to Josh's question. Another question came in from an anonymous attendee. By the way, the anonymous attendee has sent in a great many questions. Who says, do you have to say what would be a reasonable time to remedy in a section 146 notice? What do you think is the answer to that?
Yes.
Can't just say, please remedy this in a reasonable time.
You have to specify a time period, don't you? I don't know. I mean, I've
Remedy a time. I thought you could say within a reasonable.
I would follow the wording of the act, if, unless you're constrained by clear authority to specify that you pass the risk on to the tenant, then you're miscalculating what's going to be a reasonable time.
I mean, you obviously have to be careful before you take any action that a reasonable time is taken. So that, as you said, you need to have an idea in your head of what a reasonable time is. But I've seen people fall into traps where if you say what you think is a reasonable time, then the tenant will say your notice is defective because you haven't given them a reasonable time. Whereas if you just say a reasonable time, you sort of put the onus on them. I don't think someone will correct me if I'm wrong. I don't think there is an actual requirement to specify in the notice.
that you have
That
to
you
have left a reasonable
You
time.
have to have allowed a reasonable time.
That's how I've always understood it, but my memory is wasn't perfect when it was new, and it's certainly not new anymore. Right, then there were some questions online, I think directed at him. One was, would reliance on a breach that preceded the one you're hoping to forfeit for count as a waiver?
And I think so the answer to that, so I think it was a claim. If you brought a claim for breach of covenant in respect of a covenant that preceded the covenant that your right to forfeit arises from, would that be a waiver? Short answer is yes. And if you go back to those ingredients of waiver that we talked about, if you've got knowledge of a breach, whichever breach giving rise to a right to forfeit, which in this case you do, or assume the landlord does, then if you're bringing a claim in respect of any breach of covenant under the lease, whenever that occurred, you're treating the lease as continuing, unless those two exceptions I gave, you're bringing it as an alternative to a claim to forfeiture, so a possession claim, or you're having to get a determination of a breach of covenant under section 168 of the Common Hold and Leasehold Reform Act, because it's a residential lease and you're doing it as a precursor to forfeiture in that way, or a service charge dispute under the Housing Act 1996. But yes, always go back to, have you got knowledge at the time that you're treating these as continuing?
See, because I suppose the point of the question is that suppose the earlier breach which had occurred was, for example, smashing a window. You smashed a window and there's some covenant in the lease which says don't smash windows, and you claim damages, you just claim the money sum. Once and for all breach, you're not interested in forfeiting for the cost of repair. It's a crystallized breach which precedes breach that you later seek to forfeit for. In suing for the earlier breach, are you recognizing the continuation of the lease after the moment of forfeiture? I think that was the point of the question.
Understood. So not a continuing.
You're not by
breach.
that action recognizing the continued existence of the lease. You're recognizing that it continued at some time in the past. And is that conceptually problematic in the doctrine of election? My own view is that that's not a problem.
No, if it's in relation to something where that right, that claim, as you say, crystallized, I suppose at the point where you're.
Yeah, the mischief that you have to avoid is doing something that recognizes the continuing existence of the lease after the moment at which you say you have forfeited it. So if what you're doing can be confined in a pigeonhole to a moment when there's no doubt the lease was on foot, that's not that seems to me to be not such a problem. Yeah. Then we've had a couple of questions. People are interested in guarantors. What do people think? Should you bring in a guarantor if you're bringing if you're bringing a forfeiture action in court? Should you sue the guarantor? Perhaps we should take a poll. Does anyone think we should? One, as a vote of one.
This is a guarantor who's not a party to the lease, who's,
Could be a part of this.
No, but they've not been specific whether.
The guarantor would very often be a party.
Yeah.
Hmm,
You know, but probably. In terms of obviously enforcing a possession order per se, you don't necessarily need the guarantor, but they might be entitled, as Harley said, to apply for relief. So it could obviously be, it's obviously helpful to get them involved potentially sooner rather than later if you think that's something that they're going to be interested in doing. But I don't think you are required to do so at the outset if you don't.
no, but there is that bit in part 55 about naming those who are entitled.
Yes.
to-
2.4.
And I forgot to say this, but it's so critical that you do that because the court takes it so seriously. If there is a subtenant or a mortgagee entitled to apply for relief from forfeiture, and you don't name them, so you don't give them the opportunity to respond, it potentially goes to your order. You know, it could be set aside potentially if you haven't done that. Almost certainly, if it's raised by the other side, it will cause an adjournment so that you can reserve and name the parties entitled to apply for relief.
Right, we're now more or less at 6:30, which is a convenient moment, I think, to draw these proceedings to an end. So I hope you found this evening useful. And I'd like to thank the panel of speakers we've had. Thank you very much for